Hello everyone, this is Advocate Shivam Chanana, and today I'll be speaking on the topic enforcement of emergency arbitral decisions. Well, arbitration, as we all know, is one of the most famous forms of dispute resolution. And when the need of urgent relief arose, there came a new term called emergency arbitration. Now, emergency arbitration basically came into existence almost a decade ago, and since then it has become a part of almost every arbitral institution in the world. Actually, parties realized that sometimes they may need some interim relief on a very urgent basis, and they had only courts to their rescue. Now, in courts, as we all know, it is a very time-taking and a lengthy process. But the interim relief sought was very urgent. So, courts was not a good option for the parties. So, their emergency arbitration came to their rescue, and it has truly proved to be a blessing for the parties. So, International Center for the Dispute Resolution, that is the ICDR, became the first arbitral institution to come up with the provisions of emergency arbitration. And after this, other arbitral institutions in the world followed it. For instance, Stockholm Chamber of Commerce also came up with the rules of emergency arbitration. The International Chamber of Commerce came up with the similar rules. SIAC, that is the Singapore International Arbitration Center, came up with the similar rules. So all these arbitral institutions came up with the rules of emergency arbitration, to make themselves more reliable and effective. Emergency arbitration is mostly preferred by the parties to avoid the litigation, to avoid the courts, so that they may not have to involve themselves in the formalities and in the time-taking process of the court procedures. But all this seems to be very smooth, the whole process of emergency arbitration. But actually, there are a lot of problems and issues involved around it. The biggest problem with the whole concept of emergency arbitration is the issue of enforcement of those interim reliefs. For instance, like if you have sought an interim relief from the emergency arbitrator, and if the emergency arbitrator has rendered you that interim relief in your favor, but you cannot get it enforced, so the whole purpose of the emergency arbitration will get infructuous. So it is very important to get these decisions, these interim reliefs sought from the emergency arbitrator to get enforced. Even though there are a lot of issues and concerns, but then still emergency arbitration is being widely used by the parties, and there are a lot of applications in most famous arbitral institutions. A lot of applications arrive every year. Emergency arbitration basically involved a lot of different factors. Enforceability is one of the main issues, but then to reach the emergency arbitrator, you have to first prove the urgency involved as well. Only then you can at least get a emergency arbitrator appointed to render you any interim relief. So urgency should be involved, urgency should be proved, and secondly, you have to prove the nature of harm caused. It is very important that you should prove that, because if the harm is not very serious, then the institutions might avoid giving you any emergency arbitrator, or the emergency arbitrator may avoid giving you any interim relief because he may think that the harm is not that serious. So you have to prove the urgency, you have to prove the harm. Only then you can get the interim relief by the emergency arbitrator. But now if you have gotten the interim relief, so how do you get it enforced? Now, to answer this, neo-convention may come to your mind. So talking about neo-convention, it is very important to know that the neo-convention only deals with the arbitral awards and not with the procedural orders. So the convention only recognizes the awards and only enforces the awards. Now, awards are always those decisions which are final, which have attained finality. But then what about the procedural orders? What if you get an interim relief in form of an order? Now, if it's in form of an order, probably you cannot get it enforced under New York Convention. The finality factor is stated under Article 5, Subclause 1, Subclause E of the New York Convention. Though the word final is missing, but if you read that article, you'll probably be able to interpret it in a way that you'll realize that the finality is another issue. Finality is an important issue to get your decisions enforced from the New York Convention. But the interim reliefs which you get can be modified at any time in future by the arbitral institution. I'm sorry, not by the arbitral institution, but by the tribunal which may be constituted, or by the courts. But then but if an award is final, that cannot be modified. So if your interim reliefs can be modified, then they cannot be enforced either. So New York Convention is not clear with the definition of of awards or orders. It has not given any clarity on the procedural orders, which can be considered as whether they can be considered as awards under New York Convention or not. Now, some of the courts, be it a French court or English courts, they focus more on substance of the decision and not on the form. Form can be either it can be in the form of an award or it can be in the form of an order. That doesn't matter for these courts. They'll go for the substance. So considering the substance, they may realize that if it is important to enforce this decision, so they will order its enforcement. And this is a very good step actually. One of the surveys in 2015 also stated that the most important thing which parties have there in their mind before they approach the courts or the emergency arbitrator for an interim relief is the enforceability. All they want to know is how will they be able to enforce the interim relief which they'll probably get from the emergency arbitrator or from the courts. So some states have, as I told you, that some courts and some states, they focus on the substance and not on the form. So taking example of Israel and Malaysia, these are the two states which include interim award in the definition of an award. So they say that such measures should be taken to avoid any ambiguity or uncertainty, and when it comes to enforcement, interim measures should be enforced irrespective of the form, irrespective whether it's an order or an award. I'll state a quote here by Advocate Pallavi Shroff, which she has written in one of her articles, which states that, I'll read that out. This raises a debate between efficiency and fairness if the decisions of emergency arbitrator are unenforceable. That defeats the purpose of seeking emergency relief in the first place and makes the arbitration process less efficient. At the same time, it would be unfair to enforce decisions that can be modified by the arbitral tribunal or can lapse after a certain time. So she basically has tried to say that if the relief sought by the emergency arbitrator cannot be enforced, then the whole purpose of emergency arbitration gets infructuous. There's no use of emergency arbitration if the relief rendered cannot be enforced. But if at the same time you enforce the interim reliefs, then also it's wrong, because interim reliefs can be modified at any stage in the future. So that is also wrong, because only those awards or orders or interim reliefs can be enforced which have attained finality. Now, every arbitral institution is silent on whether the form of interim relief should be an order in form of an order or an award. Every institution is silent on it. There's no clarity as to whatever the arbitrator should decide. Like ICC has clearly mentioned in its Article 28 subclause 1 that any such measure shall take the form of an order giving the reasons or of an award as arbitral tribunal considers appropriate. So it has completely left it on the tribunal, on the emergency arbitrator, whether he'll be rendering the decision in form of an order or in form of an award. Similarly, the other institutions have left it on the arbitrator. So there's no clarity as to whatever. There's no, nothing is fixed. But the good part is that some states and some state laws have started focusing more on the substance rather than the form of a decision. So if you focus on the substance of the decision, then it will be very helpful for the parties to get it enforced, because after going through the decision, they may realize that that this should be enforced. So probably I'll have to conclude by saying that the arbitrator should always render the award in form of the interim relief in form of an award itself, and this will be very helpful for the parties to get it enforced without any hassle, without any problem, because otherwise the whole emergency arbitration thing seems to be vague if the interim relief is not enforced. I hope I was helpful. Thank you so much.